depending on who the attorney is, that tells me, maybe they didn't get notice with Odyssey. And so what we'll do is we'll reset it. The coordinator will reach out to that attorney, or either I'll.
I didn't check which one because I don't know which one to do.
Lupe Martinez,
Morning, Your Honor.
good morning. So what are we here for?
Excuse me, Your Honor, I was notified by Mr. Martinez that probation had informed him that he needed to come to court. Here's what's going on. He was put on probation 2 years.
All right, have you talked to probation?
Yeah. He has the ignition interlock on the car.
Okay, you're whispering a little
I'm
bit.
sorry.
The
The ragweed's getting the best of me this year. But
Okay.
anyway, he was put on probation 2 years for a DWI reduction for misdemeanor. His two priors were 50 years ago.
Mhm.
One of the conditions was the ignition interlock, which he has had on for over a year now. So his probation officer had filed with the court an application to remove the ignition interlock. It went to the DA's office for review. It was initially opposed by Mr. Garahan, so I think it was set for a hearing
Yes.
today.
Yes.
I conferred with Mr. Garahan in probation. He's not opposed, he was not opposed to it, but he did say he would leave it up to the court's discretion.
Okay. All right, so probation on this case with Mr. Martinez, have there been any violations on ignition interlock?
No, Judge.
All right. And state you have no objection to removal?
No, Your Honor, the reason initially probably why it was opposed is that usually, but if I reduce it, leave it mine, I do it for the full term.
Yeah.
But in this particular case, we'll leave it up to defer to the court for the decision.
Okay. Yes, and I did put ignition interlock down until further notice.
That's
So I
what-
don't believe
that's
either
what I
party asked for a specific length, but I did until further notice because this was reduced.
Yeah.
But I do recognize that his prior DWIs were over 15 years.
That's correct, Your Honor.
All right, Mr. Martinez, have you learned anything about drinking?
Have we drank milk?
That's right, you can't drink, right? Okay. All right, then what I will do is probation.
Yes, Judge.
I'll allow the removal of ignition interlock. All right, is there anything else?
Nothing, Your Honor.
All right, thank you. Thank you for dressing appropriately for court.
He's hard of hearing, Your Honor.
Thank you for dressing appropriately for court.
Okay.
All right, thank you.
I'll wait to the front.
I'm sorry, just one moment. Thank you, Vashawn, it just came through. All right, court is calling 2023 CR 3681, State of Texas versus Damian Huff. Can I have parties announced for the record for the state defense?
Jay Moritz, Your Honor, from Mr. Huff.
And are you Mr. Huff?
Yes, Your Honor.
All right, Mr. Huff, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes. Your
Are
Honor.
you the same Damian Xerxes Huff who was placed on deferred adjudication in 2023 CR 3681 for the offense of burglary of a habitation with intent to commit assault on July 26, 2023 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, the state is going to be, going to have a,
Well, what motions are you proceeding on?
we're going to be proceeding on violation of condition number 19.
All right, if you would read that violation, please.
Yes, on or about the 10th day of June, 2024, Bear County, Texas. The defendant, Damian Xerxes Huff, is then and there failed to attend alcohol and drug evaluation. The approved agency, TAP, BCC, SCD, in violation of condition number 19.
How do you plead to that? True or not true?
True.
And the other allegations?
But we won't be waiving all the rest.
Any objections to the state's waivers?
No, Your Honor.
Mr. Huff, did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, sentence you to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 19?
Yes.
Court will find violation of condition 19 true. Is there a proposed agreement? And what is the proposed agreement?
Follow working conditions from probation and dependent on probation, with all the conditions remain in full effect, and then also have a TAP evaluation while the defendant's in custody.
And defense, Are you in agreement?
Yes, Your Honor.
Probation, is this your agreement?
Yes, sir.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Damian Xerxes Huff.
All right, so why did you miss your TAP evaluation?
Just stuff was happening in my personal life and I just really wasn't ready, I guess, or I couldn't attend to it. So I just slipped further into my substance abuse, I guess.
I'm sorry, what?
I just slipped further into like depression and not continuing forth with what I was supposed to do.
All right, so let me explain something to you. You have to make time for probation. If you don't make time for probation, then the next question is, do you have time to make time for prison life? Because on this case, and I'm trying to stress to you, on this case, you're looking at 20 years in prison. And a lot of people will come to me and say it's just marijuana. But in Texas, marijuana is not legal. And in Texas, you're not allowed to use marijuana unless you have a medical prescription for marijuana and it's approved by probation. You understand?
Yes.
So anytime you're thinking about not doing your conditions of probation because you don't have time and other things are happening in your life, just think about the fact that you will make time for 20 years in prison potentially. Do you understand?
Yes. Yes. Your Honor.
All right. So what has been going on in your life? You said other issues.
Yeah, just personal, like with my mother and stuff, like at home.
All right. What's going on at home?
They're just foreclosing on the house and everything, so that kind of was up in the air, like where to stay and everything.
All right. So how old are you?
29 years.
All right. So you're going to have to find a place.
Yeah, definitely. And that's I've had that like like I've been on my own since about 17 and just happened when I was like 27. So I moved back to my mom's and to see this through. And then yeah, they just came to foreclose on the house for 30 grand. So that kind of just put me in an odd spot and facing homelessness and other things like that.
All right. Well, I will tell you, usually in situations like that, they want somebody to pick up the phone and talk to them. Because sometimes it's not a buyer's market. And maybe you could talk to them and see
Yeah.
what can be worked out. Maybe something can be worked out, maybe not. But the key is not avoiding.
Yeah, definitely.
And that's what probation is about, not avoiding. Just pick up the phone and call probation. You could have called them and said, hey, I know I have a TAP evaluation schedule, but I'm having issues with my living situation at the moment. Foreclosure is happening. Can I reschedule it? And I am telling you, I believe they would have said you can reschedule.
Yes.
All right, the court will follow your agreement, deny the motion, alter and amend conditions to include TAP evaluation in custody and follow all TAP recommendations. And probation, is there anything else that he would need?
I was thinking maybe possibly a felony drug court now.
All right, we'll do a referral to felony drug court, and that will be in custody. Because it's Tuesday, felony drug court will probably be able to see you this week, and you need to be honest with them, okay? And is there anything else that you need from the court to help you be successful on this probation? Like any mental health issues, any other issues you may have?
No, I pretty much understand.
All right, and probation, if for some reason foreclosures happen and they're evicted, see if you can do a referral for him with that organization, Building Better Communities. And that's an organization that can help you at least find affordable housing, okay? All right, if there's nothing else, all right, good luck. We can go off the record. If something comes up and you need something, let probation know. If you feel as though they're not addressing it, you can always come back to the court. You understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Have a seat.
And does she have a warrant or no?
No, ma'am.
Okay.
I'll wait to.
Is this still going to be a contested?
Well, Judge, I really honestly don't know. I have a request for the court. I'm not prepared to have a contested hearing today.
All right.
My request is a reset.
All right, it's going to be a short recess. And let me tell you all why. This case was brought to the court on May 22nd, 2023. and it was reset for June 1st for a contested hearing. On June 1st, she did not show at 10:10 a.m. So then a warrant was issued for arrest. She was remanded without bond. I guess somebody unremanded her. And so today we're set for a hearing.
There seems to be a little discrepancy. I don't know if the court has it on the court file. I conferred with Vashon. It says bond forfeiture
Mhm.
because when we checked the clerk's record, it didn't indicate that. It indicated a warrant had been issued on that date because of a drug court evaluation that went south, not of a mid. She doesn't recall missing a court date, and I'm not arguing with the court. She may have.
No,
I was
she
not,
did.
I was not here at that time.
No, I understand. No, I will tell you, somebody else gave her bond back. It wasn't the court because she didn't show on that date. So that's neither here nor there. She doesn't have a warrant for arrest, which is what everybody is telling us. So my main thing where we are is this motion to revoke was set on May 22nd. Then it's reset for June 1st for a contested hearing. And June 1st, a contested hearing didn't happen because she didn't show.
Right.
So now we're back on October that we've been trying to have a hearing since May. So what I'm saying is, I understand you say you're not ready for a contested hearing. It's going to be a short reset. So my reason for saying that is because it's a short reset.
I understand that. And I know you want to move this case, and I understand that as well. I don't plan on contesting the motion.
Okay.
I'm trying to get Tony plugged back in to start doing what she needs to do. And that requires a little bit more time than the court might want to give in a situation like this. But that is my ask of the court. I need her to get plugged in and start doing some things. I don't think that's a bad thing, and that's what she wants and I want. So to that end, if the court could give us 30 days, I'll defer to the court on the time, but that's my request, Judge.
All right, let me ask this, and we're not on the record. If she's drug tested today, what are the results going to be?
Should be
All
clear.
right, so let's do a drug test today.
I'm
Do you
fine.
need any water? All right, so Ms. Abrams,
Yes, Judge.
is there a place she can go to do a drug test? I can see if they'll if they'll allow her to do a drug test at felony drug court. All right, just have a seat.
Thank you, Judge.
Court is calling 2022 CR 5897, State of Texas versus Tamika Latuan Stoudemire.
Yes, ma'am.
Can I have parties announced for the record for the state defense?
Carl Basil, Your Honor.
And are you Ms. Stoudemire?
I am.
Counsel, have you received all of the discovery?
Yes, I have, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, 2 counts.
Did you review the document entitled Court Admonishments with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
I did, Your Honor.
Did you understand in each count you're charged with criminal mistrip, 2,500 to 30,000?
I did. Yes,
A
ma'am.
state jail felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
No.
Did you understand if the court were to grant your application for deferred adjudication in each of these counts? If for any reason your deferred adjudication were revoked, and each count, the court could sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
My opinion is she is, Your Honor.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Okay.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is recommending deferred adjudication and restitution to be determined. Did you understand that to be the plea?
That is, yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal?
Yes,
The
ma'am.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
Contest.
Count two, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
No objections, Your Honor.
All right, state, you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments in the court. All right, after viewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of the client?
Your Honor, I just like the court to follow the plea bargain. In addition, I think if possible, I know the court's been informed earlier that my client's granddaughter was died under suspicious circumstances, and they're still investigating that.
All right, everyone, please whisper.
So if any type of counseling or thing could be provided to her, I think it would be very helpful to her to help her deal with that. I think they're still waiting to see if there's going to be any criminal charges on that yet.
All right. All right, count 1 and count 2 will run concurrently. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Valerie Pena, P-E-N-A, and Pierre Johnson. There's to be restitution, if any, to Pierre Johnson and Valerie Pena. There's to be 100 hours of community service restitution. Do you have any children?
I do.
What are their ages?
The mother of the child that passed, she's 17. She graduated Friday.
All right, and so you have one child?
I have 3, but minor.
Okay, and how old are the other children?
Jacario is 29, Princess is 19, and again, Unique is 17.
Okay. And then I'm going to order anger management. And once anger management is completed, I'll find that the community service hours are deemed to be satisfied. Probation, do y'all have any type of grief counseling or trauma counseling? All right, so we'll do grief trauma counseling. And honestly, if there are pending charges related to the death of our grandchild, usually usually the state will provide something for that as well.
I don't think there is at this time. They're still investigating for what
Okay.
she's told me.
All right, there's to be regular reporting by Zoom or in person. There's to be regular random UAs. Are you employed?
Yeah.
All right, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 3 months. Probation, is there anything else? Is there anything else that you need from the court to be successful? Oh, okay.
Thank
You're welcome. All right, and then we'll set this for a restitution hearing. Norma, set this for a restitution hearing. We'll set it for December 2nd. That should give everybody plenty of opportunity to have whatever case law they need.
I don't think it's probably case law anyway. It's just whether it was paid or not.
Oh, okay.
That's what it comes down to.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, so we can go off the record. Here's the thing. When somebody moves on with somebody else, whether you think it's fair or not, you gotta let it go. And I always tell women who come in, I don't know why women fight with other women over a guy, because honestly, should that woman recognize that marriages are hard and they don't need outside people interfering? Yes, but they don't. And at the end of the day, even if it's a guy who's upset, don't get upset at that guy. Don't get upset at that woman who's entering into the marriage. You know why? Because they owe you zero loyalty, because that's not the person you have loyalty to. And at the end of the day, if a significant other leaves you for somebody else, you need to thank that other person, because that is now their problem. But good luck to you, okay?
Thank you so much.
All right,
We
you're
got
welcome.
divorced.
I was just gonna ask you the divorce is fine.
Yeah, we divorced already.
You know what? Congratulations.
Thank you, Your Honor.
You're welcome.
Morning, Judge.
Good morning. So are we here on a motion to revoke?
We are.
All right, are you all ready to proceed?
We are.
Court is calling 2022 CR 5371, State of Texas versus Christopher Garcia. Can I have parties announced for the record for the state? Defense?
Kyle Simpson.
All right, and are you Mr. Garcia?
Yes, sir.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, sir.
Are you the same Christopher Garcia who's placed on community supervision in 2022 CR 5371 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on July 8, 2022 for a term of 2 years? Is that you?
Yes, sir.
State, which allegations are you proceeding on? All right, any objection to the waivers?
No, you are.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you to 2 years in the state jail facility?
Yeah.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is.
Yes.
That is the agreement.
All right. I don't know why I should follow this agreement, and let me explain why. This is not his first motion to revoke. He was here before, and I know what probation is asking for, but this is his second motion to revoke. The first motion to revoke that I heard was on December 20th, 2022. It was a violation of condition number 1. The court found it true. The court altered and amended. There was an agreement. The court altered and amended his conditions to include SATF and aftercare and the UA hotline and proof of employment within 30 days from release from SATF, and then field visits. So now we're back here. And it appears that people are asking for the same thing. I've already ordered SATF before. And where has he been? Did he report? Did he not report? What's been going on with him?
Judge, he did attend SATF. He was successful in SATF. He didn't report to the aftercare. I think this is an addiction issue. I think if you let him speak.
You raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Christopher Garcia.
All right, you wanted to question?
Yeah, Mr. Garcia, last time you were in this court, you were ordered to go to SATF and go to aftercare. Is that correct?
Yes.
And you attended SATF, is that right?
Yes, I think so.
And when you got out of SATF, did you have a relapse?
Not like right away, but just when, yeah,
Okay,
I'm sorry, I can't hear you.
it was a relapse.
Okay.
and due to your relapse, is that the reason why you did not go to the aftercare program like you were ordered to by this court?
Yeah.
And the judges wanting to know why this time is different. Do you plan on going to the aftercare program after you get out of SATF this time?
Yeah, I'm planning to go this time, yeah, because of the fact that now I have the ways of doing this. Now I can attend whatever it is I need to attend, but I already did, what was it, in 23 or 22? That I attended SATF.
You did, but part of SATF is is the continuing obligation to comply with the court's orders, one of which was the SATF aftercare program,
Okay,
which you did not do. So
but this time I'm willing to do that, the aftercare.
I understand that you're willing to, but what in your life is different now that's gonna help you succeed that wasn't in place in your life last time?
Oh, I'm not doing the crystal meth anymore.
Okay, let me just tell you, you're whispering and mumbling.
Mhm.
I can't hear you
Okay.
and I need to hear you. I'm sure the court reporter is struggling to hear you, so you're gonna have to speak up. So you're saying you're not doing crystal meth anymore?
No, I'm not. Mm-mm.
Okay. So that SATF is not going to take him because he doesn't have a drug problem.
If you tested today, would you be positive or negative?
No, I'll be negative.
Okay, when's the last time you used crystal meth?
Was probably like a month ago maybe, but that was just because I had gotten back on it just before I came over here.
Are you telling this court that you do not have a drug problem or that,
I don't have a drug.
have you ever had a drug problem?
No, yeah, I mean, that's what I got arrested for the first time, but that wasn't a problem. It's just something I caught.
But then you relapsed
Yeah,
and you've relapsed as recently as 1 month ago. Correct?
yeah.
You think that SATF would help you address some of the problems that you have right now?
Only one way to find out is I guess if they were accepting to go.
Is that something that you want to do?
I'll do it.
No further questions.
All right, any other questions?
No,
All right, the court is going to grant the motion. The court is going to revoke. Does anybody want to speak to length of time? Because his underlying is 2.
I don't know how many days he has in, but 303, Judge.
Oh, is that what you're requesting?
No, I was just informing you that it's
Okay,
303
okay.
days. But yes, as a matter of fact, 303 days, I think could be excellent.
All right, state, what are you requesting? All right, the court is going to grant the motion, revoke you, give you credit for any time served. Court will sentence you to 2 years in the state jail facility. And I'll give you credit for any successful inpatient treatment.
Judge, would you consider the diligent participation credit?
Yes.
Thank you.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes.
All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, and what I'll also order, I'll ask for therapeutic community. If you discover that you have a drug problem, then they may be able to help you, okay? All right, good luck to you. Larry Berry. Who's the attorney for Larry Berry?
I think you can step down.
Simon Hernandez. All right, if you come down. And is there an application?
He is not wanting to apply, Judge.
Okay, all right, court is calling 2024 CR 008919, State of Texas versus Simon Anthony Hernandez. Can I have parties announced for the record for the state? Defense,
Albert Chidas for Mr. Hernandez.
and are you Mr. Hernandez?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he was on both occasions.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at a cap of 8 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, ma'am. I was trying to figure if I might be able to get 6 months and
Oh, no. So let me stop you there. I'm just going over what the plea bargain for you is.
yes, ma'am.
And then your attorney, if he wants to, he can argue for less. So according to this plea bargain agreement you reach, it's a cap of 8 months in the state jail facility. So what that means is that the court could sentence you, if I found there was sufficient evidence to find you guilty, the court could sentence you anywhere from 180 days up to the 8 months. Do you understand?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence.
Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses that the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. At the time of this offense, my client was homeless, no ID, no job, nowhere to live. What happened was an act of desperation on his part. He knows that, he knows he shouldn't have done what he did. He's trying to get his life back together. It would be helpful if we could keep the sentence at the minimum. The state is at 8, we're at 6. We're asking for 6. He doesn't have an extensive criminal history. He's just a guy who was homeless and saw an open car and got in. Shouldn't have done that.
All right, so what is his criminal history?
Because of Odyssey, it's a little hard for me to
All right,
print
what's
it
your
out.
criminal history?
I had a possession charge, got dropped in the past. I had a terroristic threat. There was against a public servant, there was a misdemeanor. I also ended up having a trespassing charge, and before that, I think I fell asleep at a swimming pool. I forgot what I was arrested for, but I was arrested for falling asleep at the swimming pool. I didn't find nothing on me, nothing like that. I just was arrested for it. They told me I was resisting arrest, I think it was.
Okay. Yes. Any objections to the court reviewing the criminal history?
No objection.
Thank you. And how old are you?
27.
All right, state.
Yes, Your Honor.
I'll hear any argument for time.
Understood. Well, I think what Mr. Hernandez really means is that it was easier for him to take advantage of someone else in order to help himself. And from that perspective, 8 months seems more appropriate as a punishment for this offense.
All right, so Mr. Hernandez, I don't understand why, if somebody is homeless, which I understand there's an issue and people are homeless, and being homeless is not a crime. I don't understand why people think the go-to, and I should say some people think the go-to when you're homeless is, oh, let me commit a crime because I'm homeless. And then spare me, I was homeless, so I stole a car. and you stole a car and you drove it and you didn't have identification, you didn't have a license, and you didn't have insurance?
I would like to say it's not that I stole a car, it was sitting at a park. I mean, no one told me I could drive it, but no one told me I could. Like it's
Oh, okay.
I-
So,
truthfully, it was just there and unlocked. It
so there was a
left out.
vehicle there that was unlocked. Was that your vehicle?
No, ma'am.
Did you pay for it?
No, ma'am.
Did somebody have a for sale sign on the outside saying anyone who comes upon this vehicle, you have the permission to take it?
No, ma'am. I just seen an on car just there, and it was hot outside that day. I really had nothing to eat, nothing like that.
So
nothing
you just
going
took
on.
the car?
I didn't take it, ma'am. It was still at the place that it was at.
Mhm.
I didn't go any.
Oh, they
really
found
go
you at the
where-
park with the vehicle.
Where I found the car,
Mhm.
there at that park. I didn't go anywhere except for one time, just I went down the road real quick, came right back and stayed at that park.
Mhm.
I didn't take the car from there, nothing like that. I found it there on and running. So I sat in it for a while. Whenever the cops see me, I was outside the vehicle.
And your bags were in the vehicle.
Just one, yes, ma'am.
All right, the court will find you guilty. The court will sentence you to 8 months in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Let me explain something to you. Whose ever car that was, and they have the complainant's name in here, guess what? They go to the store, whether they leave their car with the keys running or whatever, they should be allowed to do that. Should you do that? No. But I'm sure when that person came from wherever they were, they're probably thinking, oh my gosh, did I park my car somewhere else? They're looking for their car. Next thought, was my car towed? But it couldn't have been towed because I parked it in an appropriate place. So that person, let's say that person had an infant with them and they come out and it's hot because you said it was hot. They come out with an infant. No, let's say it's hot. They come out with an infant and their car is gone. Now, guess what? What is that person supposed to do? Oh, I see a car here. There's nobody in it. Let me just take it. Guess what would happen if everybody here, I'm sure everybody here has seen a vehicle before where maybe the keys are still in it or maybe nobody's sitting in it. What do you think would happen if everybody here said, you know what, I don't want to take the bus today, but this car, I know it's not mine. I'm just going to get it in and drive it away.
I doubt almost anyone in
Yeah.
here has been through a rough time.
And you know what?
sometimes.
And then, hey, guess what? This house, the door is open. I don't have a place to stay. Let me just go in here and claim this home as my own. Yeah, that's not happening. We're not in the middle of a zombie apocalypse. So there are laws, and one of the laws are don't take what doesn't belong to you. Good luck to you.
Thank you.
Luz Briceño. Let me just find him on the docket.
He's the last one, Judge.
Okay. He is not the last one.
He wasn't the one we just looked at. I'm sorry.
Okay, let me find him. There we are. All right, so you're late for court. Don't be late for court, okay? All right, and thank you for dressing appropriately for court.
Thank you.
All right, so where are we on discovery?
I think that we're good on discovery. It's still pre-indictment, so.
Okay.
I don't know.
Okay, I just want to make sure y'all have discovery, so,
So far, yes.
okay, awesome. All right, and then there is a motion to modify bond conditions. Have you had a chance to review it, State? Are you both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, we're going to go on the record. Court is calling NIMAC number 751772, State versus Luz Briceño. Can I have parties announced for the record for the state?
Joseph Holscher for Mr. Briceño.
And are you Mr. Briceño?
Yes.
All right, the court is in receipt of a motion to modify conditions of bond. All right, defense, you may, and state, are you in agreement?
No.
All right, defense, you may proceed.
Your Honor, we've previously approached and you had modified the conditions to partial house arrest. Mr. Briceño works in construction, and so his schedule is fluid as he gets calls to go out for different projects. Right now, he has to call pretrial services and let them know what his hours are, if they're going to vary from the hours that the court pre-approved, and also where he's going. And he's been doing that. There's been no violation reports. However, he's still missing work because sometimes they're he's not getting a response from pretrial
Mhm.
rapidly enough for him to get sent out. They'll call him and they'll say, Luz, we want you to go do
Well, isn't he
this.
on tracking only?
I mean, that's what I understand.
So, I mean, there should not be any issue with him going places because he's on tracking only.
He's still supposed to report to pretrial services and they are very
Who's his
difficult.
pretrial services officer?
Can't remember. We had him before, but at this point, he's still pre-indictment.
But no, who's his pretrial service officer?
Mr. Larson.
Okay, so I need to, like, what's the name? Because it's not coming up.
Julio Larson. It is definitely Julio.
Okay. Let me see if they can zoom in.
He did once before.
Okay. All right, I sent an email for him to zoom in, so if you all just step back, just give us a moment.
Sure.
Okay. And we will take care of things. All right, thanks. Christopher Lee Gonzalez. Hello, come up. Good morning.
Good morning, Your Honor.
All right, so where are you all on discovery?
I have the discovery. I gave a copy of what I had. I gave it, let him read it
Okay,
today. And he would like a trial. We have an offer, which he's rejected. And secondly, he would like another attorney.
all right. So with regards to having another attorney, if you would like to have another attorney, you're more than welcome to have another attorney. You'll have to hire that attorney. Do you understand?
I don't have any funds to be able to hire my own attorney, but I just want to state that this is the first, I've been incarcerated since June 15th, since this alleged incident occurred.
Mhm.
And this is the first time I've even spoke to.
All right, so let me ask you this. So you all have now met, right?
Right.
Do you need to speak with him anymore? Because
Oh.
if you do, I mean, the box is available for you all to sit and talk. And then I'm sure that he'll talk to you by Zoom at the jail or either meet with you in person at the jail. So here's the thing, and let me explain this to you. Sometimes attorneys, like this system, Odyssey, you know, Odyssey is what Odyssey is. There have been some issues with Odyssey. Sometimes attorneys do not receive notice that they've been appointed to represent you, so they don't know. And this is a first setting case, and what I can tell you is it's a first setting case, and there have been some times on Odyssey where I have a first setting case, right? Which means it's the first time it's been before me. It's the first time that it's been on the docket for the court. And guess what ends up happening? Sometimes when people are on bond, they don't show and their attorneys don't show. And when their attorneys don't show, depending on who the attorney is, that tells me, maybe they didn't get notice with Odyssey. And so what we'll do is we'll reset it. The coordinator will reach out to that attorney, or either I'll text that attorney and say, hey, you have someone on the docket. And it never fails. Usually, you know what that attorney says? Oh, I didn't get notice of that. So maybe your attorney did not have notice, but he has notice now. He's here. You can talk to them. You can talk to him as long as you, well, not as long as you want to, because we're taking a break at noon, but you can talk to him. You understand? So here's the thing. Let's say that this is the first time you're meeting him. You have met him. He's saying he has all the discovery. He has brought an offer to you. Again, this is what I've discovered in my time on the planet. Sometimes the state will tender an offer, and maybe my client would not be ready to receive that offer, right? They're not ready, because maybe I have to build my relationship with them and tell them, hey, this is what's happening in your case. But that was the way I did things. Some other attorneys are like, hey, I got all the discovery. Here's what this case is about. Here's the police reports. This is what they're offering. You can accept it or not accept it. And that's completely up to you. Sometimes people would get offers and they would say, this is crazy offer. And guess what I would tell them? Hey, it's the offer that the state is tendering you. Ethically, I have to give you this offer. Whether you want to accept it or not is completely up to you. If you want to go to a jury trial, we can go to a jury trial, right? A defense attorney can't force a prosecutor to give you an offer that you would like. Once your attorney has tendered the offer to you, you can either accept it or reject it, right? If you decide to reject it, some people will say, hey, I won't take A, B, and C, but if they offer me D, E, and F, I'll accept D and F, D, E, and F. That's what's called a counteroffer. Then your attorney will take that back to the state, and the state can think that your counteroffer is ridiculous. Although in this court, I always tell people, please don't say that offers are ridiculous, because then it just ratchets things up, right? And we try to keep things level. So that's what he can do. And then the state can say, no, I'm not accepting that. The only thing we'll accept is A, B, and C. And then you have a choice. You can either agree to A, B, and C or not. If you choose not to, then it'll be set for trial. If you decide you want to do a bench trial, a lot of people think, oh, well, I just want the judge to hear this, so that's what I'm going to do. That's not the way that works, because the state is entitled to a jury trial. You're entitled to a jury trial. And if you want a bench trial where the court just hears the evidence and make a decision, both parties have to agree that you'll go forward with the bench trial. And what I can tell you about bench trials in this court, I've had bench trials where people have been found not guilty, and I've had bench trials where people have been found guilty. I just will listen to the evidence. And guess what? If somebody's charged with a murder case and the state doesn't prove their case, it's not guilty. If the state proves their case, whether you're a great guy or not, it's going to be guilty. You understand? That's the way things are run. So your attorney is here now. If you still want another attorney, then you will have to hire an attorney. Do you understand? All right.
Can I just say this?
Sure.
I've been kidnapped, honestly. I don't have any clue what the heck this thing is about. A
Well,
rock
here's the
being
thing.
thrown
This
or
is the
anything.
thing.
But
Time out. Let me just tell you, because I don't want you to get into the facts of your case, because maybe your attorney doesn't want the state to know what the facts of your case are going to be. This is not California where there's reciprocal discovery. Maybe there's something that he wants to be a surprise to the state. So what he's giving you and going over with you is the police reports to tell you what this case is about. The only thing I know about this case is you're charged with evading arrest detention with a previous conviction. That's all I know. I don't know any facts of your case because none have been presented to me.
I don't know why would they give me evading arrest. I wasn't doing, I didn't do anything
Here's the
illegal
thing.
to put me in an
That
arrest.
means that maybe you want a jury trial, but talk to your attorney. And if you want a jury trial, I am here to give you one. Okay.
Okay.
All right. So just talk to your attorney a little bit more, and then you guys can reapproach. All right. Thank
Okay.
you. Thank you. Thank you. All right. On Brasillo,